Yes, good afternoon, Mr. West.
Good afternoon. My Lord, it's fair to say that until today, the claimants have taken their stand on these applications.
You're going to have to speak up a bit because it's a noisy court.
It's fair to say, my Lords, that until today, the claimants have taken their stand on the question whether there is or is not a conflict between the defendants. We maintain that there is no real conflict between them on the matters to be addressed by the experts, and the tribunal agreed, and we maintain that the tribunal was correct to say that. And we did not seek to contend below, in view of the ruling in trucks to which the court has been taken this morning, that there should be a single expert even if there were conflict, and we did not seek to distinguish the ruling in trucks. However, as is apparent from the discussion this morning, the more general point of principle as to whether there is a jurisdiction to require parties to share experts, notwithstanding any conflict, it must be arguable. And that's apparent first, even from the case of an expert retained by a single client, whose duties to the court may require him or her to give evidence which goes against that client's interests, because the expert's primary duty is to the court. And that was recently re-emphasised by this court in the Royal Mail and Daff appeal by Lord Justice Green, and it is shown even more clearly in the case of a single joint expert shared between the claimant and the defendant in a case where clearly the respective clients or instructing parties will have diametrically opposed interests. And as mentioned by my Lord, Lord Justice Arnold, before the short adjournment, there is some guidance on the circumstances in which it would be appropriate or inappropriate for there to be a single joint expert shared between the claimant and the defendant. I recalled some cases on that from the early days of the CPR, and we've managed to fish out two very short extracts over the short adjournment, which I can hand up if that would assist.
You can send them electronically, that would be helpful.
I'm not sure I can do that now, I'm afraid.
No, but I'm sure it can be done by your junior in fairly short order to my clerk.
Can I hand up the physical versions in the meantime?
What are you looking at?
There is an extract from Phipson on Evidence, which identifies the principle, cites an authority, which is very brief, and I also have that authority.
I mean, just for future reference, Mr. West, I don't use paper. I can't see paper and I don't use it, and that's well known. And so if you want me to look at things, no, I don't want the paper very much. You have to send it electronically or it doesn't get looked at.
I'm very sorry about that. I wasn't aware of that. Can
Pretty
I
well
just
known now
read
in
out?
sports.
It's a matter of a couple of sentences. Paragraph 33-60 of Phipson.
Sorry, which paragraph of Phipson?
33-60.
Thank you.
And beginning 3 lines from the end, in heavy and complex cases, the use of single joint experts is quite limited. In areas where there's more than one school of thought, particularly where the evidence goes to a central issue in the case, it's inappropriate to insist on a single joint expert, as the choice of the effect would effectively decide the question. I think that should say the choice of the expert would effectively decide the question. And the authority cited, footnote 486, is the authority I've handed up, Oxley and Penn Warden, a very brief judgment of this court in the very early days of the White Book. This was a case in which the claimant had unfortunately suffered the amputation of one of his legs below the knee.
What's the neutral citation number?
It is, this may be from before those came in, I'm afraid, took the year 2000.
What's the date of the case?
21st July 2000.
Doesn't have a neutral citation number on it.
I'm afraid it was from before those.
And who's the court?
Lord Justice Kennedy and Lord Justice Mantell. The case is Oxley and Penn Warden.
Yeah.
And the question, there was an issue of causation as to whether it was the alleged negligence which had led to the claimant's misfortune. and the judge below imposed a single joint expert on that question of causation. The Court of Appeal reversed that, and its essential reasoning is at paragraph 8. In my view, this was eminently a case where it was necessary, this is Lord Justice Mantell, eminently a case where it was necessary for the parties to have the opportunity of investigating causation through an expert of their own choice, and further to have the opportunity of calling that evidence before the court. It's inevitable in a case of this class that parties will find the greatest difficulty in agreeing on the appointment of a single expert. That burden would then be cast upon the court and would in turn lead to the judge selecting an expert if there be more than one school of thought on this issue from one particular school of thought, and that would effectively decide an essential question in the case without the opportunity for challenge. So that is, I believe, my Lord Justice Arnold's reference to there being a range of schools of thought on an issue. And so effectively in this case, there was a body of respectable medical opinion which would have upheld causation, and another body which would have not upheld causation, and in those circumstances the court thought it was unfair for there to be a single expert.
So you accept then that if the point seems to be against you, really, you accept, do you, that if there is a range of plausible expert opinion about econometric models, it could be, it would be open to 20 defendants with different interests to instruct one person in that range. Is that the right position?
No, I accept that there is a limit to the ability of the court's power to require parties to share an expert. And the limit of it, as expressed here in Phipson, is whether there's a range of schools of thought and the issue to which the expert goes is a central issue in the case. In the Oxley case, that issue would have been determinative of whether the claim succeeded or failed. By contrast, in the example of something like a valuation expert, it may not be a central issue in the case, but simply a question of quantum, which still leaves the parties able to argue whatever the issues of liability are in the case.
Sorry, I didn't understand why quantum is different from liability as a matter of legal principle.
Well, the question, I think, must go to whether the imposition of a single expert would effectively prevent the party from being able to either prosecute or defend its case.
Why does that matter? I mean, the question of quantum is as essential to a defendant as it is to as his liability. And once liability is established, the question of quantum is critical.
Well, it may be, depending on the case. The parties may be very far apart, or they may not be terribly far apart, and as we know, the court tends to resolve quantum issues with a broad axe in any event. But my point is that the limits of the power, as expressed here and supported by the authorities...
So could I ask you, what is your legal submission as regards the really single legal submission that Ms. Ford made very clearly to us this morning, which is that as a matter of law, it is not appropriate to impose joint experts on defendants where there is a clear conflict of interest.
My submission...
Is that correct or not correct as a matter of law? It sounds as if you agree with that.
That cannot be correct.
Cannot be correct.
Cannot be correct as a bald proposition.
So what is correct as a bald proposition?
Well, certainly simply the existence of a conflict is not enough. The position would have to be, as suggested by these authorities, that without a separate expert, the defendant is effectively unable to defend itself, or in the case of a claimant, it's unable to prosecute its case. Effectively, whatever the expert says on the central issue in the case is going to be determinative.
Well, you're going to have to spell that out in words of one syllable as to what submission you make. I mean, Mr. West, I find it pretty unhelpful to look at two people, unreported cases from the Court of Appeal 25 years ago, when things have completely moved on since then, or notes in textbooks or any other commentary. We are deciding a question here of basic principle as to expert evidence and when it's appropriate, and you're facing a very clear submission from the appellants, which I've just put to you. Now, what is your submission in contrast to that? It's not just, it cannot be, well, you can impose a joint expert when it's not really important, which is what basically you were saying. What is the proposition of law that you contend for?
The proposition of law for which I primarily contend is that the mere existence of a conflict is not sufficient to mean that the parties are entitled to call their own experts. One would have to go further and show that in the absence...
Just don't take it too fast. The mere existence of a conflict is not sufficient to entitle a party to call its own expert, right?
So
you have to go further.
In the absence of
Yeah.
a separate expert, the party would have to establish that it is effectively disabled from prosecuting or defending its case.
The parties have to establish that it would be disabled from presenting or
Prosecuting or defending its case, depending if it's the claimant or defendant.
defending its case. Okay. Thank you.
And I apologise for the fact this has not been worked up in greater detail, but these are matters which clearly arose in the course of the discussion this morning. If the court would be assisted by this, it may not be. It may be sensible for the parties to produce brief further submissions afterwards in relation to this new particular point which arose this morning.
But the problem, Mr. West, is you say it's a new point, but it's completely obvious that the court can require a single expert where there is a conflict of interest, as epitomised by the single joint expert, and indeed the rules of the Competition Appeals Tribunal that allows the tribunal to appoint its own expert if it wishes. So the whole case may have been proceeding on a premise which is, what should we say, sort of oblong, if I can put it that way.
I agree, that's how it now appears, and as I've explained, the explanation for that, such as it is that the parties have been proceeding on the basis of what the Chancellor had to say in the Trucks case.
Well, as my Lord pointed out to you earlier, the Chancellor was talking about a very special situation where the Road Haulage Association was instructing an expert on behalf of parties with different interests.
Yes, and another explanation for the outcome is along the lines I've been submitting, because in the case of direct and indirect purchasers in a cartel case, their ability to prosecute their claims depends on pass-on. Because if there has been pass-on, the loss passes from the direct to the indirect purchasers. And if one therefore has a class consisting of direct and indirect purchasers with a single expert opining on pass-on, that expert may take the view that in this particular market, there's a low level of profitability or high level of price sensitivity which results in a high degree of pass-on, and that effectively means the direct purchasers are denied their ability to prosecute their case. Their own expert is saying, you haven't suffered a loss, even though there may be another body of expert opinion which takes a different view of the conditions of competition in the particular market and which would enable the direct purchasers to run their own case on pass-on and for the court to decide.
Well, that's exactly what these defendants say here. They say they would effectively be prevented from pursuing their case if they're not allowed to have their own expert who uses their own data to show that what can be demonstrated by way of causation in this case. And they say that would necessarily be different for each group, because the group 1 was not involved in one part of it, group 2 was, they may have been involved in different ways at different times, and so there has to be their own ability to produce their case. So you agree with Miss Ford, do you?
No, absolutely not. I'll come on to whether there's a conflict at all, but in my submission, even if she is able to identify some relatively theoretical conflict, It's in relation to highly peripheral matters, very different to the
What
case
if it's not about a conflict at all, as you say, but it's about whether they're disabled from presenting their case? That is much stronger for her, because even if there's no present conflict as to the presentation of their liability defence, there is undoubtedly quite a different position as between the two groups as to their participation in cartel arrangements of great complexity over many years. So it is not arguable that they weren't doing different things at different times, and that could well lead to different liabilities. I mean, that seems to me, I would be corrected from either side or from somewhere else if I'm wrong, but that's my understanding of the position. So
Well,
on your test, she's satisfied.
I will come on to the question of whether there are conflicts, but as I say, the conflicts in this case are, as I say, in relation to highly peripheral matters, which would have a minor impact, if any, on the liability. Quite different from a case of pass-on between direct and indirect claimants, where it's been recognised for many years, going back to Emerald Supplies in this case, and much longer in this jurisdiction, and much longer in the US, that there is a direct conflict between those groups of purchasers, such that they cannot form a single represented group. The reason why I'm addressing you on why there may be limits to this is that we wouldn't want to give the impression to the tribunal that it would be appropriate for there to be a single joint expert between all of the parties in this case. And so there has to be limits to the extent.
Why not? I mean, is it not the logical endpoint of the tribunal's own reasoning that the most preferable way to deal with matters would have been such a single joint expert?
Well,
Because one of the points that, as I explored with Ms. Ford this morning, that the tribunal makes is that it was concerned about the prospect of having to deal with different methodologies being advanced by different experts. And of course, the more experts you have with different methodologies, the more that concern is compounded. One can understand that. But the logic drives you then to say, well, how do we avoid that problem? Answer, we have one expert applying one methodology.
that's exactly why I'm addressing you, as you might think counterintuitively, on the fact that there must be a limit to this. For example, the existence of an overcharge is relied on strongly by the claimants in this case to demonstrate that there was a cartel at all. If the claimants are unable to adduce expert evidence on overcharge, that's a substantial plank of their case that there was a cartel in the first place, which was directed at them or which had effects on the prices they paid, it becomes unavailable to them. So we say at the very least it must be possible for the claimants to have separate experts from the defendants. And that's why I rely on these authorities concerning the limits of the court's jurisdiction to impose single joint experts in all cases. But we say it doesn't apply as between different defendants who have broadly the same interests. We're talking here about defendants, co-defendants to a cartel case.
Well, I understand the submission you've just made, but would I be right in understanding that your response would be the same to the question my Lord the Master of the Rolls asked earlier, which I don't think you answered directly at the time, which is, what about a tribunal-appointed expert? Because, again, thinking through the tribunal's concern, a single joint expert, jointly instructed by the parties, might be regarded as one way forward. But another way forward is for the tribunal to instruct its own expert rather than having party experts. And of course, as I'm sure you're well aware, in many European courts, court-appointed experts are regarded as being the right way forward, particularly because the perception is that it avoids party affiliation and consequent bias.
Well, that may be one solution. It may depend on the ability that the parties then have to put matters to that joint expert and to seek to challenge the tribunal expert's views in due course, however those may be expressed. That isn't the situation we're facing in this appeal. And if the parties are still effectively able to put their case, as it were, to to the joint expert or to have input into the process, whereby the joint expert opines that there may be no problem about that.
Can you just explain to me how you say that the parties are presented or disabled from presenting or defending their cases if there is not one expert on each side, but the defendants are not presented from presenting or defending their case if they don't have an expert each?
Well, it may come down to the importance of the expert evidence. In the case we looked at, the success or failure of the case as a whole turned upon that expert evidence. In other cases where one is dealing with more peripheral issues, one doesn't have the same stark contrast.
This is not a case where the expert actually decides the issue before the court, before the tribunal, as to whether or not there was a cartel. The expert's model simply indicates whether there is correlate evidence of correlation. Correct?
As I said a second ago, the claimants also do rely on the fact that their expert has found a cartel overcharge for their case that there was a cartel.
The defendant, the claimant.
The claimants. So the claimants say that there must have been a cartel which affected us, either a direct cartel or an umbrella cartel. How do we know? Because our expert has examined this in very great detail and has found that prices were higher during the cartel period after adjusting for anything else which might have affected those prices. What explains the fact that there was that overcharge? We say it must be that there was a cartel, because everything else has been adjusted for.
Yes, but not a cartel in which the defendants were necessarily participating, and that is what the court has to decide. I'm sorry to keep on saying the court.
Well, that may be correct, and so we have other evidence to establish that the defendants were participating in the cartel, and these are all, of course, purchases from the defendants. So it's the defendants' prices. If there's been a price increase in the goods which the claimant purchased, it's in the prices they purchased from the defendants, because the only value of commerce in the case are purchases by the claimants from the defendants. So it's their prices which have increased.
I don't want to misunderstand it. The expert evidence is that there is an effect for which the only explanation is a cartel. The expert doesn't know if there's a cartel, because that would be direct. You'd have to actually go and find so-and-so talking to so-and-so.
Correct.
But that's the nature of the evidence.
Yes. So it's not the only evidence we rely upon for the cartel. We didn't look at it in detail in the pleadings, but there are paragraphs and paragraphs of particulars, if one wishes to call them that, explaining why we say that there was a cartel and giving further particulars of the particular conduct relied upon. And similarly, in relation to the umbrella effect, there are particulars given of why we say that a cartel directed against another party by a defendant would have had an effect on prices of goods that they then sold to the claimants. Because, for example, profit margins were set in such a way that they applied across the defendant's customers, or prices were set by reference to benchmarks, which included cartelized benchmarks. I won't get into the details, but yes, we rely on evidence of that kind, but we also rely on the existence of the overcharge. But to summarise, it must be correct in my submission that simply pointing to a conflict of any kind cannot be a trump card, and the examples to which the court has referred in the course of submissions today demonstrate that. Can I therefore now address briefly the question whether there is a real conflict in relation to the matters to be addressed by the expert evidence? And that's an important qualification, because in order for the existence of a conflict to be an issue which affects the ability of the expert to pronounce, it must actually relate to the subject matter of the expert's evidence, what he or she is actually going to say. And in general terms, the position taken by the defendants in this case is aligned. Clearly, my friend has been focusing on the respects in which it's not aligned, but in general terms, it is aligned. Both defendants admit the cartel conduct found by the Commission, as they have to do because it's binding on this court as a pre-Brexit decision by the Commission. But they both deny that there was any conduct going beyond that, and in particular, they deny there was any conduct directed at the claimants or that the claimants suffered any loss. So on the face of things, they are running mutually consistent defences rather than conflicting defences. And as we've seen, the tribunal concluded that there was no real or genuine conflict between them. And there are two matters in particular to which my friend points to say that there is a conflict. First was the question of apportionment of loss between the defendants in subsequent contribution proceedings, and the second concerns the claimant's claim for umbrella damages. And if I can just therefore address those briefly, we say no question of apportionment arises because there are no contribution notices. The court will not, at the trial in Michaelmas term of this year, be apportioning the loss between the two defendant groups. The primary case pursued is one of joint and several liability for a large overall cartel to which both defendant groups were at all material times parties. And on that case, there is therefore no need for any apportionment of any loss.
So, as I understood Ms. Ford's answer to that point, what she argues, and this is my paraphrase of her argument rather than the words she used, is she says, you may be right, legally speaking, on the current pleadings, there's no conflict, but she says as a matter of commercial reality, the conflict is inescapable.
But again, I say that that doesn't have anything to do with anything the experts are doing. My friend's reason for saying that this is a matter the experts are addressing is that Mr. Hughes, the claimant's expert, breaks up the value of commerce in this case between the two defendants. And so she says that's him expressing a view on how the loss in this case should be apportioned. But of course that isn't what he's doing. He says in terms, although I'm for convenience breaking it out between the two defendant groups, the claim in this case is one of joint and several liability, and therefore Autoliv is liable for JF sales and vice versa. But more to the point, it's difficult to see how Mr. Hughes could have avoided doing that, because damages in a cartel case are calculated firstly by determining the overcharge percentage, 5, 10%, whatever it may be, and then multiplying that by the value of commerce, that is, the sales which were affected by the overcharge. One must therefore have a figure for value of commerce, and as I've explained in this case, the only value of commerce sued upon are purchases from Autoliv and from ZF. And therefore, in order to reach a value of commerce figure, you need to take the sales made by Autoliv and those made by ZF and add them together. I don't see any way that the expert could do that without referring to the volume of sales made by each. But although he has addressed that in order to carry out his calculation, the determination of the value of commerce is not itself a matter calling for the exercise of his expertise. Instead, he simply takes the parties' data on how much was sold of each product category by each of the defendants to each of the claimant groups. And as my friend showed you this morning, Mr. Hughes actually points out that you get a different figure if you take the claimant's records than if you take the defendant's records, and so he does the calculation on both bases. What he's not saying is that he's had to undertake a complex econometric analysis in which he has had to make judgments about the inputs in order to get a figure for value of commerce. And so we say calculating the value of commerce does not give rise to a conflict of interest on the part of the experts. It's not a case in which if there were a single expert for the defendants, he or she would be saying, I can't give a figure because whatever it is going to make the defence by one or other party impossible to run.
Presume it's also the case that, for the sake of argument, if there was a reason why a figure in the column for Autoliv it was put that it should be reduced, it doesn't necessarily mean there's any change to the figure for the other for ZF at all. It's not as though it's a cake where you're moving the boundary between the shares of the cake. They're two independent variables.
It's a relatively mechanical exercise, and Lord Justice Birss says it's not a zero-sum game. And indeed, at the hearing below, when Professor Neuberger put to my friend, "Are you really saying there's a conflict in relation to the value of commerce?" she appeared to accept that she wasn't saying that. I can show you that if that's of interest. It's tab 20 of the ADD bundle, page 34. It's referred to in our supplemental skeleton argument. And my friend took you to paragraph 1.5 of the Contribution Act. It wasn't actually clear from her submissions what finding in favour of one of the defendants she thought might be invoked in subsequent contribution proceedings. But in any case, the tribunal also pointed out that they could simply say in their judgment, we're not resolving any issue in these proceedings in relation to the attribution of loss, ultimate attribution of loss between the defendants. So we say there isn't an issue of attribution, and it isn't something that the experts are going to be addressing. At any event, not by means of material which requires them to bring their expertise to bear. The expertise they really bring to bear is in the multivariate regression analysis, which determines the overcharge. And the overcharge in this case is a single overcharge as regards all of the value of commerce. There aren't separate overcharges, but even if there were, the defendants are jointly and severally liable for them on our primary case in any event.
But that doesn't apply to the umbrella claims.
No, that's what I'm coming to now, the umbrella damages claims. So these are all follow-on claims, which mean the infringements at issue have already been found by the Commission, and the details as to who participated and for how long and so on, and in relation to which products, are set in stone. There's no scope to argue about it, because it's a follow-on claim following on from the Commission's decision. And the claim is that although those cartels were directed at other car manufacturers, the existence of those cartels is likely also to have led to increases in OSS products purchased by the claimants, not least because those purchases were from the defendants who were parties to those cartels. And as I've said, there were two, as my friend has said, there were two different decisions, OSS 1 and OSS 2, finding two different groups of cartels, which operated concurrently between 2007 and 2010. Prior to 2007, it was only OSS 1, which was in operation. And as my friend has said, ZF was a party to OSS 2, but not to OSS 1. My friend has taken you to the tables in the particulars of claim, setting out the detail as to precisely which car manufacturers were targeted, how long each cartel was in operation, the periods of time for which each of the participants took part in those cartels, and so on. And it might just be useful to pick that up again. This is the additional bundle tab 1. Paragraph 20 and 24. So one sees between 20 and 24 there are 6 different infringements with different participating undertakings, different targets, different periods of participation. And at the earliest point in time at which Autoliv took part in any of the OSS 1 decisions was the 28th of March 2006. That's the very last entry in the table at paragraph 20. Autoliv joined this cartel later in some cases, but that's the earliest point at which it was part of this series of cartels. And then in the OSS2 cartels, the earliest point at which Autoliv and Takata, I believe, both joined was January 2007, as one can see from the table at paragraph 24. So there is a maximum period of 6 months during which Autoliv was party to OSS1, but OSS2 had not yet come into operation. But overall, there were some 6 different cartels with different start and end dates, different memberships, and so on. And what the defendants appear to say about this is that their expert will be in a position to opine in his or her report, not only on whether prices were higher during the cartel period, whatever one takes that to be, there's obviously a debate about starting dates, compared with a clean period. Not only will he or she be able to do that, but he or she will be able to say this part of the overcharge is attributable to this cartel, and a different part of the overcharge is attributable to a different cartel. And therefore, because Autoliv and ZF were parties for different periods of time, that gives rise to a conflict of interest. And the answer to this, the main answer to this, concerns the nature of the regression analysis, which we've already looked at. And it was explained in the Royal Mail and Daft decision that regression analysis involves looking at prices which prevailed over a cartel period and a clean period, adjusting for factors that might have affected prices other than the cartel, and seeing what's left. And if what's left is a positive difference in price during the cartel period, the inference is that that was due to cartel activity. And CORP pointed out in that case, it doesn't establish causation, but causation is an inference from that, from the results of that analysis.
And am I right in understanding that the reason is because you try and think of all possible causative effects and allow for those in your model, and if you're still left with an effect that is shown by the model, when you've allowed for all possible other causes, then by a process of elimination, the only thing that's left is a cartel. Is that the reason?
That's exactly it. It's a process of elimination. But what it doesn't enable the economists to say, assuming they find that overcharge by a process of elimination, is it's this particular cartel configuration which caused that, or this particular defendant, or for example, it's a direct cartel rather than an umbrella effect. That's not a matter that the experts can address. That would be a matter in my submission for the court to address at the trial, having looked at the evidence.
So what is not a matter the court can address, the expert can address?
If a cartel overcharge is found, they're not in a position to address the question of which cartel resulted in that, if there was more than one concurrent cartel or more than one alternative allegation concerning cartel conduct.
Why not?
Because the process, as we looked at earlier, takes a dummy variable, which is what's left after you've adjusted for everything else, and it's either a positive figure or a negative figure.
Well, it can take a dummy variable, but it can take a dummy variable for different participants in the cartel. So if, for example, there are if there are 3 members of the cartel in cartel number 1 and 2 members of the cartel in cartel number 2, and they overlap, and the defendant number 1 is a member of only one of them, the expert might want to try to show that the overcharge was due to the second cartel, not the first cartel, and vice versa. I mean, a silly example, I'm sure, but it's the kind of thing. And that's what Ms. Ford submitted to us. She said, in the umbrella claims, because we are participants in quite different cartels at different times, any expert is going to be looking at the global position, whereas we would like to break it down and show that our participation didn't cause any significant overcharge or cause less overcharge than theirs. And that gives rise to a potential conflict. I mean, you might say, well, they're not deciding liability, but you can't say it's all joint and several and that's what our claim is, which is what you say on your standalone claim.
My answer to that is there's a couple of points to it. One is the one I've already made about there being 6 different cartels.
About what?
About there being 6 different cartels.
Yes.
OSS 1 and 2.
Well, that's her whole point. There are 6 different cartels at different times.
Well, at overlapping times. And the idea that it's going to be possible to attribute what is effectively simply a finding that prices were higher over a period of time to any one to the exclusion of the others, in my submission, is just, it's not going to be possible. And I don't have to rely on my submissions for that because our expert has said so.
Her expert
Our expert, the claimant's expert.
says what? That's not Ms. Ford's expert, hasn't
No.
said so.
She's not said, Miss Ford's expert has said nothing. That's one of my important points to which we're coming to. But the letter from Mr. Hughes is in the additional bundle at tab 2. This was a letter.
Sorry, I've got several additional bundles. Which one would you like?
It's ADD, it's labelled.
This is number 2, behind the particulars of claim.
Yes.
Yes, okay. Which paragraph?
Second. So, Mr. Hughes was ordered to produce this analysis by the tribunal. I can show you that order, but it's paragraph 4.3. What he refers to as the secondary case is the umbrella case.
Is it the sentence just at the foot of the page? During the overlap period, both cartels or operations, not possible to disentangle the effect of an individual cartel that can be observed as their combined effect.
That's for the overlap period, and then he addresses the non-overlap period.
Sorry, where does he?
It's in the next paragraph.
Right.
By contrast, the period when only those cartels identified in the first decision are in effect is only a few months. That's the 6 months between March 06, it's the 6 months or 9 months. The 9 months is March 06 to January 07.
But I mean, this is not, so you say there's no evidence to contradict this.
Exactly. This was submitted in December 2022. Since then, the defendants applied again to the tribunal, and their case was their expert wants to do something which Mr. Hughes says is not possible. They were asked whether they wished to put in any evidence in relation to the question of conflict. Their answer to that is in the letter at tab 14.
So this is an important point. You effectively say the regression analysis is not ever going to be sufficiently sensitive to disentangle multiple cartels and show different overcharges for different participants because because when you have things starting and things finishing in a higgledy-piggledy way, the pricing is not that sensitive. So all you can do is take the global position, take out other potential causes, as doing the exercise my lord suggested, looking for causes. And once you've done that, you get a global figure for the overcharge, which is blind to the fact that there were 6 cartels operating, one for 10 minutes and one for 3 weeks and one for 3 months. I mean, that's simplicity, making it simple. One could imagine, if one were not an expert like me, one could imagine that that's correct up to a point, but that if there were a lengthy period and there were distinct cartels going on for a long period, that it would be potentially possible to do a little bit of disentanglement. Would you accept that?
Exactly.
Yeah.
So if the non-overlapping period had been 3 or 4 years instead of 6 months or 9 months, Mr. Hughes may have been able to calculate a separate overcharge. The model regression model is a data-hungry model. You do need a certain minimum amount of data to get a statistically significant result. So I don't know what the figure would be in years.
No, but price elasticity is slow, basically.
Indeed.
Yeah. Okay. But you say this is, I mean, what you say effectively. Sorry, just to try and put it in my own language, is that Ms. Ford may be able to say that something could be done, but this is a very far from a real justification for for a special expert.
Exactly.
Which is going to obfuscate the. So that's what you say.
That's what I say in my submission. That's really what the tribunal said. They asked her, what does your expert intend to do? And she couldn't answer. What does she intend to do apart from the regression analysis Mr. Hughes has done, which identifies whether there was an overcharge in the cartel period or not? Answer came there, none.
Well, the answer may be that expert intends to do it in a different way with a different and entirely plausible method, which would give rise to the problems the tribunal identified.
Well, there wasn't any evidence to that effect.
Mr. West, I think you were going to take us to a letter that was in reply.
Yes. Sorry, this is perhaps not the most important point, but
Okay, well,
paragraph 14 is probably worth mentioning.
Paragraph 14.
Sorry, it's tab 14 of the ADD bundle, which points out in the second paragraph that claimants had suggested the defendants file further evidence in the conflict of interest issue. This is in advance of the...
Sorry, I think I've got the wrong letter.
Tab 14 of
Page
ADD,
230.
Page 230. So the defendants were given a deadline. If you're relying on any further evidence on this issue, whether there's a conflict or not,
Yes.
please submit it. In case it assists the tribunal, they do not consider it necessary to file any additional evidence. In relation to conflicts of interest, it's a matter for submissions.
Mm-hmm. Yeah, okay.
So that's why there isn't any evidence. There wasn't any before the tribunal, and there still isn't any. And so perhaps unsurprisingly, given the state of the evidence, the tribunal's finding was all the experts can do is say, was there an overcharge during the cartel period? Mm-hmm. And so far as that's concerned, the defendants' interests are entirely aligned, because it's in their interest to say either that there was no overcharge at all, or if there was, that it was as small as possible. And my friend also suggests that what our expert would like to do is work up an analysis whereby some part of the OSS2 overcharge under the umbrella case was attributable to OSS1 by comparing the overcharge during the OSS1 period with that during the OSS2 period. And quite apart from whether that's something which is possible to do given the data in this case, there's no suggestion in the pleadings of that type of cutthroat defence between the defendants, whereby one of them is going to be saying, yes, there was an overcharge, and it's your fault, not mine.
Well, there's not much cutthroat when you haven't got a contribution notice. They're certainly keeping their knives in their pockets.
Indeed. What we have at the moment, as far as the defences are concerned, is nothing to see here, no cartel against you claimants, and no overcharge at all. Quite different from, yes, there was an overcharge, and it was your fault, not mine. And this explains the judgment. These factors, I hope, explain the most recent judgment of the tribunal, which is all about the matters I've just been explaining. So in tab 21, which is the most recent judgment, starting at paragraph 10, this is the point that the defendants were unable to inform the tribunal what they intended to do, other than to say they weren't in a position to prejudge the outcome. And my friend took you to these paragraphs. Importantly, at 13, it's not suggested the defendant's expert will do anything other than identify the presence or absence of an overcharge during different periods. And then at 17b, the defendant's positive case is that there is no umbrella effect arising from the decisions, not suggested by ZF. They intend to argue that any overcharge in the period prior to their participation is caused by an umbrella effect arising from OSS1. Although theoretical conflicts could be contrived, it's necessary to keep in mind the scope of the expert evidence. As we've said, all the expert evidence can do is identify the existence of an overcharge. It's a blunt tool and not capable of distinguishing causes of that overcharge. It follows that if, which is unlikely and which is unpleaded, a conflict arises as to whether an overcharge in the period, that's the 9-month period, was caused by an umbrella effect, and the expert evidence will not be relevant to the resolution of that issue. So in my submission, the position was before the tribunal and remains before this court that any suggestion of a conflict in relation to the expert evidence remains purely theoretical or hypothetical. It hasn't been shown to be genuine or real. Now, my friend in her supplemental skeleton and again in her submissions said, well, the defendants are not in a position to adduce material from their expert because that would involve a waiver of privilege over the draft report, and therefore they simply cannot put in front of the tribunal, or for that matter this court, the evidence from their expert, to the absence of which I have been pointing. And that is another bad point. We've seen an example of just such a letter already, the one from the claimant's expert, Mr. Hughes, in December. It wasn't suggested then that there'd been any waiver of privilege over the draft of Mr. Hughes' report by virtue of that letter. And it's notable that the defendant's separate intended experts both supplied letters in support of the original application to vary. And we don't have those letters, but what we do have, it's a very brief point this, what we do have are the witness statements served on that original application. They're in the supplemental bundle. Mr. Firth's statement is at tab 5. And page 128, paragraph 17. He refers to the second line of that, something called ECA's letter. Now, ECA are the intended separate experts for one of the claimant parties. I can't remember which at the moment, sorry. Autoliv, I think. ZF, sorry, ZF. So ECA are the intended separate experts for ZF. Set out here at 17 that ECA explain various things that they intend to do. What matters is not the detail of that. The tribunal looked at this and held there wasn't a conflict. It's just that there was obviously no difficulty about submitting a letter from ECA at that stage, and no suggestion of a waiver of privilege. And Autoliv did the same. That's tab 9, page 179, paragraph 21.
So which bundle are you in?
This is the SUPP supplemental bundle.
The supplemental bundle as opposed to 129.
179 of the supplemental bundle.
179.
Paragraph 21, which goes over from the previous page, and one sees there, third line up from the end of 21, a reference to a letter supplied by Professor Dr. Frank Meyer-Rigaud, who is the Autoliv defendant's intended separate expert, who provided a letter which was duly annexed to this witness statement. As I say, we don't have the letter, the detail doesn't matter, but what this shows in my submission is there's no privilege difficulty about supplying a letter from the expert saying this is what I intend to do and this is what I believe I'm able to do. And the absence of any such evidence in my submission, the obvious conclusion to be drawn from it is that the expert's not able to do any of these things.
So, I don't want to take you out of your course, but I've been looking at your extract from Phipson, which came electronically, thank you very much. And that does seem to set up a number of hurdles to the appropriateness of single joint experts and the court requiring experts to be other than individual party experts. And what I'm interested in knowing, and I'm unattracted by your suggestion that we get supplemental submissions later, but I remain to be persuaded if that really is necessary. What your submission is you made clearly your submission that conflicts of interest are not determinative, and secondly, you've shown us that there isn't a real conflict at this stage, and the tribunal was right about that. But what I'm struggling with, bearing in mind that this is a court composed of the head of civil justice and the deputy head of civil justice, but we don't give a judgment that is in ignorance of authorities that have been, and that extract from Phipson really refers to a vast number of matters which have not been rehearsed in the argument. And I know your submission, when sort of pressed by me, some might say worse than pressed, at the beginning of your submissions was that the party mustn't be disabled from presenting or defending their case. But what I'm sort of worried about is there are all sorts of indications in the Phipson article that it does depend on the value of the case, it depends on how important it is, that proportionality is really important, that whether delay is going to be caused, blah, blah, blah. And obviously in this case, none of that is really significant. So it certainly would help me if you could formulate precisely what you say is the legal question the tribunal ought to have been answering in deciding whether or not to require defendants to use the services of a joint expert in a field such as this, because we discussed this morning what this field really is, what is expert about the evidence. And to me at the moment, I still think that what is expert is the method, rather than pressing the button on the black box, as Miss Ford put it. And I don't understand at the moment what the evidence before the tribunal was about the difference in methods, whether they pleaded, do the defendants plead a different method of doing the regression analysis? Do they say, or do they just say nothing about it and they're going to pull out an expert who does one that's beneficial to them? I mean, what are we grappling with?
Well, the first point to make is this is about single joint experts between the claimant and the defendant. So that's why I mentioned it, but it may be that the principles are not exactly the same.
Well, they may not be the same, but they may be relevant, may they not?
Indeed, that's why I raised it.
I mean, that was my Lord Justice Birss's point at about 10:31 this morning.
In relation to the evidence about the different method, I did show you a second ago the witness statements which were submitted on the original application to vary. And I can only summarise them because they're relatively detailed by saying what was really proposed was using different data rather than a different methodology. What was really suggested is that Autoliv would wish to focus particularly on Autoliv's data, whereas ZF would wish to focus on ZF's data. And so it was said that that was a good reason why there should be separate experts. The tribunal...
But is different data a justification for different experts? Because it seems to me that a joint... I mean, I'm ignorant of all these things, but it seems to me at first sight that an expert is performing an expert analysis, an econometric analysis, which he or she is able to say, this will give me a result in which I can be confident of not causation, but at least the other word I've now forgotten. Correlation, exactly. But once that method is established, you can put whatever data you want in the model. And it would be open to the party without an expert to say, well, I've put my data into the joint experts model and I get this result, and the consequent then cross-examine on that and say, look, therefore it shows something different. So that's not an expert exercise, that's a calculation. Once you've got the model. Correct or wrong?
Yes, correct. And I hope I'm fair in saying that there wasn't a different methodology suggested. The methodology is the multivariate regression analysis, the suggested justification for requiring separate experts, leaving aside the conflict point, was that they wished to focus on different data sets. The tribunal considered that and concluded that, as far as it was concerned, that would be positively unhelpful, because you would then have different analyses which were themselves based on different data. And the tribunal thought it would be very much assisted by having a single expert on the defendant side who would look at all of the
But anyway, it
available
wouldn't
usable
be
data.
something they couldn't do, because they could feed their data into the model as a matter of factual activity. Don't need an expert. That's the accountant. When the accountant's simply adding up a column of figures in Excel, that's not an expert activity.
That may be something of a simplification, because there may be judgments to be made by the expert when inputting data about whether it needs to
But
be
I thought
adjusted.
the judgment was in deciding which factors to exclude in the overcharging analysis. So, for example, you might say, I'm going to exclude the fact that cotton for making seat belts has gone up in price between 2005 and 2007 by 48%. So we must take that out of the analysis, assuming seat belts are made of cotton. I have no idea. And somebody else would say, no, you wouldn't do that, because plastic, which they also make seat belts out of, didn't go up. I mean, or went up by the same amount. I mean, is that an expert job?
That may be something of a simplification of how the model is developed. There may be an iterative process whereby the data is run through, and if it produces certain anomalous results, that then means there need to be adjustments to the model. So whether it's simply a question of being able to generate a model independently of the data and simply plug the data in, I don't think I could say for sure that that is the case.
But there isn't any evidence about any of this.
There isn't, no. And so if it was being said that there are particular benefits, leaving aside the question of conflict, which in themselves mean that there ought to be separate experts, and the defendants are not able to pursue their case in the way that they would like without those. As I say, the only one identified so far is they said, we know our own data and therefore we want to use that data.
I mean, can I put it squarely to you? What troubles me about this case is the idea came not from you, but from the tribunal. Everybody then argued the case on the basis that the whole question was whether there was a conflict. And Ms. Ford still stands on her her submission that that is the case. But there's obviously from the discussion a possibility we might not agree with that. We might say, no, it's not all about conflicts. But that then gives a problem, two problems really. One, there's no respondent's notice saying what your position is, although you've helpfully told us what you think it's going to be. And two, is it really for this court to substitute its own discretion for the discretion of a specialist tribunal in a specialist matter where the tribunal members can reasonably be expected to understand regression analyses and econometric models much better than we can at all? So should we, A, even if we think that Ms. Ford is wrong, decide the question ourselves? Should we send it back to the tribunal to decide it on whatever basis we decide is the proper legal question, or uphold the tribunal on the basis that it's an expert tribunal which we shouldn't interfere with unless it's got it wrong on law, and it hasn't. But of course, if I'm predicting correctly, it may have done. Then we're left with that problem. What do you say we should do?
Well, in my submission, you can decide to appeal on the basis that there isn't a conflict and that the tribunal was correct about that. You can also indicate that you have some doubts about whether that is in fact the correct approach, but it's not a matter you're in a position to decide.
Well, I mean, we sort of are in a position to decide what the law is. That's sort of our job.
Well, that was the next possibility. Is you could go on, if you feel you've been sufficiently assisted by submissions, either now or unattractive as it is afterwards, decide the point as to what the test is. If it isn't that, which the tribunal applied, I can't at the moment see any basis upon which it would be necessary to remit the matter.
You can't.
I would also point out that there are now pressing timing issues. The reports, the defendants' appeal reports are due on the 24th of May and the trial starts on the 1st of October.
So you'd urge us to try to hear it, to decide.
Yes.
Mr. West, can I make sure I've understood what's happened? As I understood it, this is something, I think this is, I'm going to paraphrase Ms. Ford and probably get it wrong, apologies for that. There were essentially two issues below. And one was whether as a matter of case management, the tribunal preferred a single expert from the defendants or two experts. And the other question was whether the conflict of interest issue meant that despite the fact the tribunal preferred a single expert from the defendants, it should have accepted that it ought to have allowed two. As I understand it, what the appellants have done is on this appeal is not appealed the first point, although they don't accept it's right. They didn't appeal it. What they appealed was the second point. And so what stands is the tribunal's ruling that it would prefer to have a single expert from the defendants, not two. And the issue on appeal is whether that was precluded by law because of the existence of a conflict of interest.
Because if I can just add, Lord Justice Popplewell only allowed ground two, and ground two is about conflict of interest, full stop.
Yes. Yeah. I agree with all of that.
Where does that leave us?
Well, I mean,
So it leaves us to only deal with the conflict of interest question as a matter of fact. But that's embarrassing for a court which, if it disagrees with the premise on which everybody's previously operated. Okay, well there we are. Get it.
I had no further submissions on conflicts or anything else, unless I can assist you further.
Well, Mr. West, thank you very much. Ford, I would value some help on those latter points.
My lord, yes. Given that it's a joint instruction, I believe that I will need to take instructions from both parties as to what we say that is the position on that.
Well, we've got time. Would it help you to have 5 minutes?
I suspect it would. Yes, please.
Right, 5 minutes at least.
All rise.
Yes.
My Lords, dealing firstly with the point that arose immediately before your Lordship's rose, it has become clear that this court is thinking about matters somewhat differently than the tribunal appears to have done, and that there is a degree of lack of clarity about the applicable principles, the way in which this power on the part of the tribunal to give directions in respect of expert evidence should be exercised. In our submission, the way forward in those circumstances might be for this court to hand down a judgment giving such guidance as it thinks appropriate as to the applicable principles for a question of this nature, and then the matter to be remitted to the tribunal for the tribunal to apply the guidance that it's been given and to revisit the issue in the light of that guidance.
Yes. And now the $64,000 question. Assuming that you are wrong, that the trump card is conflict, and assuming that Mr. West is wrong in saying the trump card is the party's ability fairly to present their case because of the risk of what we might loosely call, we're taking my Lord Justice Arnold's example this morning, which was nothing to do with this case, what we might call churning, doing it just in order to run up the fees and not for any good litigation purpose. So that might not be the correct approach. What do you say would be the watchword for the court deciding on expert evidence, bearing in mind, obviously, the overriding objective, bearing in mind the fact that CPR Part 35 is framed in terms of restricting expert evidence, the court being in charge of expert evidence, and the notion that an expert owes the duty to the court. So with that, and maybe I can just suggest, is it the interests of the administration of justice? The court has a discretion as to whether to order a joint expert in a situation like this, and will take into account all the matters we mentioned, but will ultimately only allow the expert evidence if it is appropriate in the interests of the administration of justice. I mean,
My Lord, I hesitate to endorse a formulation of administration of justice because it is a vague proposition.
yes,
And
it's the best I could do in a
well,
couple of minutes.
indeed, it's a problem that we've all been grappling with.
Yeah.
If your Lordship is against me that conflict of interest is a trump card, it nevertheless leaves open the possibility that conflict of interest is a relevant matter that must be weighed in the balance with other factors in reaching a view as to expert evidence. And part of the substance of this appeal was whether or not the tribunal had approached it wrongly in proceeding on the basis that there simply was no conflict of interest that needed to be weighed in the balance in that way.
But you anyway would put as your fallback position that there should be a balance.
My Lord, yes, I do maintain the submission that the issue of a conflict of interest between parties is of a different nature, a different order than questions of case management.
Yes,
Even if expressed as questions of administration of justice, I do maintain that submission.
Well, you go so far as to say it is a trump card, and we will have to think carefully about that.
My Lord, yes.
Yeah, well, that's very helpful, actually. Thank you.
Moving beyond that point, I had 5 short points by way of reply. The first concerned Mr. West's reliance on the passage from Phipson. The The first point to point out is that if one were to apply the test in Phipson at 3360 that Mr. West drew the court's attention to, in our submission, the outcome would be that we would be entitled to instruct our own expert.
3360, wasn't it?
It was, and it's the final sentence really on which he relied and on which I also rely. And it says, in areas where there is more than one school of thought, particularly where the evidence goes to a central issue in the case, it is inappropriate to insist on a single joint expert, as the choice of the expert we think would effectively decide the question. So, is this an area where there's more than one school of thought? In my submission, it is very clearly the case that in relation to how to specify an econometric model, once one gets beyond the basics of let's use an econometric model to try and do this, once one gets to the question of how does one go about formulating, building that model, that is, in my submission, an area.
No, that's not a different school of thought. A different school of thought is where you have two or more recognised bodies of opinion within the expert community in question as to the correct answer to a particular live controversy. You have identified no live controversy within the field of economic modelling at all. All you have shown us is that each individual expert is capable of reaching different conclusions on the facts of any particular case as to which inputs one selects to put into the specific model for that case. That's not two schools of thought at all.
My Lord, my submission, what the principle is really getting at is not whether or not one can properly call it a school of thought or not, but whether or not either the court would be assisted by hearing the possibility that there are alternative approaches, or the parties should have the opportunity to put forward to the court the fact that there are alternative approaches. There is controversy that would not be aired if one simply had a single expert who would not look at both sides of the possibility.
But there's no suggestion that your expert, whether you have one or two, will be applying a different basic methodology. On the contrary, as I understand it, it's very clear that they will be following the same basic methodology. They will just be argument about the variables.
My Lord, yes, I don't dissent from that. It's right that they are each envisaging some form of econometric analysis. I do say that the inquiry is whether or not either the court will be assisted by receiving multiple opinions rather than assuming that the matter can simply be dealt with by a single expert, or whether or not the parties should fairly be given the opportunity to put that forward. And that is supported by the rest of this sentence, because of course it says particularly where the evidence goes to a central issue in the case. It might well be that because it is central, the court is assisted by exploring the different ways in which that central issue might be approached. And for completeness, given that, well, first this issue has come up, and secondly the court has indicated that there is this other question of how one goes about, what factors one takes into account in appointing a joint expert. There was material before the tribunal at first instance that cites some additional authorities on this. I'm referring in the supplemental bundle, tab 8. And this is Mr. Firth's fifth statement, which was put in support of our application to vary the order. And it's page 168. Starting at, in fact, 167, starting at paragraph 32, where he says the potential complexity and significance of economic issues is also, in my view, another reason not to limit the defendants to a single joint expert. He draws attention to the commentary in the White Book at 35.7.1 that says that the court's discretion to direct the instruction of a single joint expert will more usually be capable of being exercised where it appears to the court on the information then available that the issue falls within a substantially established area of knowledge, and where it's not necessary for the court to sample a range of opinion, or where the issue is uncontroversial. Just pausing there in my submission, that does bear out the submissions, my Lord, that I was making to my Lord Justice Arnold just now. He then cites... Can
you assist me? The author of this document is a solicitor, is he not?
My Lord, yes.
What are his qualifications as an economic expert?
My Lord, he's not putting forward this as a matter of economics. He was putting it forward essentially to give the tribunal a background in the authorities that might bear on its judgment. And I simply refer to it on that basis because the court has raised the question of whether there are other authorities that may bear on the question. And I draw attention to the fact that below there was further information on this.
Well, it's useful for us to be apprised of the authorities. It doesn't matter where they come from, we can look at the White Book ourselves.
My Lord, yes. So Mr. Firth has drawn attention to 3 other cases. 32.1, he refers to a Court of Appeal case, Chesterfield and North Derbyshire Royal Hospital, and that authorised the appointment of 2 experts for the same party. And the value of the case was 1.5 million, and the justification of the court's approach, the Court of Appeal's approach, was a case of this importance, high value and complexity, and that's citing paragraph 23 of the judgment, and a case of this monetary value and importance. And so a factor that feeds in on this court's authorities to the question of joint experts is the value and the complexity and the importance of the case.
Yeah, we've seen the rest of it, yeah.
Yes, and then similar points from Mid-Cheshire hospitals make well turn out to be at the heart of the case, serious importance, etc. And then one in the competition context, 32.3. This may be of relevance in that the application by the claimant was for a single joint expert on the grounds of its own impecuniosity, which is almost approaching the proposition that my Lord was discussing before the short adjournment about the tribunal appointing an expert. The tribunal was not attracted to that, and it said the issues in this case relating to causation in particular are very substantial, and the justice of the case requires that the defendant should be able to obtain their own expert evidence.
Whilst judges who did big cases have been historically somewhat opposed to joint experts, in the county court, joint experts are very common. And so, you know, we may, sitting in these rarefied parts, we may be able to point to a whole host of cases where High Court judges have said, oh no, this case is really important and you can't possibly have a joint expert. But joint experts were introduced in a flourish in 1999 and have been quite widely used, are quite widely used. But anyway, this is very helpful, thank you.
My Lord, that was the first point. Second point was that Mr. West was asked to formulate a test which explained the circumstances when the party can insist on their own expert. And the test he formulated was whether or not the defendant would be disabled from defending its case if it were required to have a joint expert. And as my Lord, the Master of the Rolls, fairly anticipated, our position would be that we would satisfy that test. We would be hindered in advancing our case if we were required to have a joint expert. But I also go further and I say that that does dovetail with the concept of why a conflict of interest is problematic, because it does raise the possibility that the party is in difficulty fully and properly exploring matters that they consider to be important in respect of their case with their expert. And it might well mean that the joint expert, in reaching the various judgments and assessments and choices that they have to make in putting forward their model, reaches a different justifiable position when asked to take into account the position of 2 parties rather than, and potentially to reconcile potentially inconsistent positions of 2 parties. They may well reach a different position if they were simply asked to express their opinion in respect to the situation of 1 party. And I do maintain my submission that none of that is in any way inconsistent with the duty that the expert still has to the tribunal. The expert is still obliged to be absolutely candid if it considers the case is not arguable or if it is weak. They must still be clear with the tribunal the basis on which they're expressing their opinion and not advance cases that they consider to be problematic, and be clear if they think that they're not strong. None of that is in any way inconsistent. But we do say that a conflict of interest is a situation where there is an obstacle to a party being able to advance the case, applying the formulation that Mr. West suggested. So that's the second point. The third point is that Mr. West made clear that the claimants are relying on the existence of an overcharge to show a cartel. And so his submission is that the claimants can point to the fact that their alleged overcharge and say we rely on that to show that you were party to a cartel. The existence of an overcharge might conceivably show one of a number of things. It might be purely as a result of umbrella effects arising from a single decision. It might be purely as a result of umbrella effects arising from both OSS1 and OS2 decisions. It might conceivably, and this is presumably what the claimants would want to say, evidence the existence of a cartel as between the defendants. It might evidence the fact that one defendant was party to cartel but not the other. One could conceivably see that that might be what it evidences. And in our submission, none of the defendants' positions in meeting those cases, in grappling with this fundamental way in which the claimant puts their case, their position is simply not in any way on the same. They are in different positions, and their interests are in conflict in meeting the way in which the claimant puts its case. So that's the third point. The fourth point concerns apportionment, and my Lord Justice Arnold put to Mr. West a formulation of our case that although there is not a pleaded contribution claim, in fact it is, and the formulation was commercially inescapable, that issues of apportionment arise between the parties. And Mr. West did not in fact disagree with that. What he said was, it's got nothing to do with what the experts are doing. But he did not disagree with the proposition that issues of apportionment are commercially inescapable. He went on to then try and explain why his position is that it has nothing to do with what the experts are doing. And he first referred to the fact that Mr. Hughes has relied on joint and several liability. And the court has my submission that I made before lunch, that just because Mr. Hughes has recorded that that is the claimant's position doesn't mean that what he is doing is irrelevant as between the defendants. And it was then said, well, Mr. Hughes has traversed this material because how could he do any different? He has to traverse this material in order to express his views. To which we say, well, exactly. The evidence in issue in this case for the purposes of establishing an overcharge necessarily traverses this material, and we are entitled to respond to it. And we say there are conflicts between the defendants in responding to that material. My Lord Justice Birss put to Mr. West that it's not necessarily a zero-sum game, in the sense that if one knocks off a few purchases from Autoliv, that wouldn't necessarily then be transferred over to ZF. That is one possibility, and if there's simply purchases allocated to Autoliv which shouldn't be there at all, then of course the claim value reduces. But the other possibility is equally true. It might well be that one knocks off sales from Autoliv and they get transferred over to ZF. And that is the possibility which gives rise to the risk of conflict. My Lords, the final point concerns the umbrella claim. Just a point of clarification. I think Mr. West may have inadvertently said at one point that this is a period of 6 months, a maximum period of 6 months, when Autoliv was a party and ZF was not. It's not in fact 6 months, it is 9 months. It's the period from the 28th of March 2006 to the 4th of January 2007. And there was then an exchange where it was discussed to what extent the fact that there is this period where there is no overlap might be able to be taken into account in trying to investigate what's driving the overcharge. And Mr. West relies on his claimant's expert's view that, in his opinion, he doesn't think you can do that. We, the defendants, are obviously entitled to test the correctness or otherwise of that.
But you produced no evidence before this court to show that he's wrong.
My Lord, that's entirely fair, we have not. But our submission is that cannot be the basis on which a tribunal adjudicates whether or not there is a conflict of interest. In our submission, this is the submission I made before lunch, these issues normally arise essentially at a point where the expert's thinking is relatively embryonic and where the decision has to be made on the basis of the pleadings as they stand. In our submission, it's simply not appropriate to require a defendant to waive privilege in the developed product of their expert analysis in order to satisfy the court that there is a conflict.
I don't understand that. Can you help me? Because as I understand it, the point being made is that Mr. Hughes, who is a qualified expert, says no expert can opine on this question. That's his opinion as an expert, that no expert can opine. And if you want to say he's wrong about that, don't you need a contrary expert to say, yes, an expert can opine on this question? It's not to say what the result of the analysis will be, it's is it susceptible of analysis or not?
My lord, he doesn't, just for clarity, he doesn't go so far as to say no expert can do this. The conclusion is at page 62 in the additional bundle. The conclusion of the paragraph that we referred to was, I expect that there will be insufficient data to separately identify the individual effects of specific cartels over the very short periods of time they operated in isolation, and overcharges in subsequent cartel periods are likely to be effective on cartels that operated in the immediate past.
All right.
So he's expressing...
So his view, based on what he'd seen at that point in time, was insufficient data. And if you want to contend that there is sufficient data for a meaningful analysis to be carried out, then you have to produce some evidence of that.
Well, my lord, in my submission, we are entitled to explore the question whether there is or is not insufficient data with our experts, and we are not obliged to essentially air that exercise with the tribunal in order to establish that we're entitled to do it. And Mr. West made an important concession in that respect, because he accepted that if a longer overlapping period existed, then it might be doable. And so he is not suggesting that there's some absolute bar to it being done. It's all a question of degree. And in our submission, whether or not it is doable is a question of expert judgment that we are entitled to explore with our own experts, and that's what we are being prevented presently from doing.
Ms. Ford, if this point was the only issue in the case, and I know it isn't, I do understand that, but if it was, then, and this was a case management hearing, and one party came to court and said, here's a letter from my expert who says there's insufficient data to do this. And the other party came to court and said, we want to call an expert to do the very thing that this person says can't be done. I'm bound to say, I rather think the court wouldn't give you permission to call expert evidence at all.
My lord, that does rather reflect the way in which these issues have arisen, because there's certainly been an evolution. We, below, were running both case management points and conflict of interest points. The tribunal has largely tried to take the view that there is no conflict of interest at all. We have contested that and said, no, there really isn't a conflict of interest. And now at this relatively late stage, we're now focusing down on, okay, well, there is a conflict of interest, but what do you say you can do about it? And it is, I take your lordship's point that if matters had been focused to this degree straight away, one might indeed attempt to address what has become a very central point, but it really isn't the way these things have developed. And I do think that there is a question, I do submit that there is a question of principle here about what a party ought ordinarily to be required to do to enable the tribunal to adjudicate these issues, because this is going to arise again and again. It normally arises early in the case when there won't be this degree of clarity about what can and can't be done. And in my submission, it's important that the tribunal reaches its judgment without requiring an excessively intrusive analysis of what's going on in the party's internal work with their experts. My lords, unless I can assist further, those were my 5 points in reply.
Thank you. Well, thank you both. Thank you all, actually, for what has been, I would say, a very interesting argument. We will take time to consider our judgments. We'll hand them down in the usual way. I assume you'd like them as quickly as possible. I don't think you're going to get them tomorrow nonetheless, but we'll do our best. And when you get them, please suggest corrections, use the judgments only for the purpose of agreeing costs and an order, so as to adhere to the embargo. And if you want to argue about costs or the order, we will hear that argument in writing. Thank you very much.